Thank you all for joining us for our Privacy and Cybersecurity in 2025 Key Developments and Insights webinar. My name is Alex Cameron, and with me is Kateri-Anne Grenier, and together we co-lead the Privacy and Cybersecurity group at Fasken. Before we begin, I have a quick housekeeping slide, and in particular would draw your attention to the survey. We really do value your feedback on our sessions and encourage you to fill in the survey before you exit the session today. And in addition, I would note that today's session qualifies for a variety of professional credits. And so at the end of the session, there will be QR codes and links to obtain certificates for that purpose. If you don't have a chance to fill in those forms today, you'll receive a certificate next week. And in preparing for the session, we have tried to address the questions provided in advance by those who submitted questions in advance. We'll try to address those in the course of the sessions. However, if you would like to ask a question during the presentation, or if we haven't got to the question that you raised, we certainly encourage questions to be submitted, and we will have a question and answer time at the end of the session, and we'll also try to address them throughout where possible. There is a Q&A section on the webinar platform for that purpose. And so with that introduction, we'll hand over to our first group of speakers. We have a lot of important content to get through, and I'll hand it over to Daanish, Nareg, and Alex.
Hi, everyone. Thanks for joining us today. Our session will focus on cybersecurity trends. I'm joined by my colleagues Daanish and Alex Shapiro, both in our privacy and cybersecurity group, focusing on cybersecurity matters. In today's brief session, we're going to cover some incident response trends, so providing you an update on general trends, focusing then on ransomware and, of course, artificial intelligence. Then we'll jump into regulatory developments, both discussing new regulations that have come out and some point of views from regulators and decisions. And thereafter, we'll dive into the litigation landscape and give you an overview of what that looks like. So without further ado, I'll pass it over to Alex Shapiro, who will take you through incident response trends.
Thanks so much, Nareg. So talking about general incident response trends, we're generally still seeing quite a bit of ransomware. A lot of ransomware engagements, which, they may not carry in all cases the same reputational stigma as they once did, because now they're so common and people are getting often getting desensitized to it, but not to downplay it, because organizations are still being judged on their ability to respond and recover to these types of incidents, especially since they're more common now. And there's a lot more expectations around people who are getting, for example, notices with respect to confidentiality incidents. We're also seeing plenty of email compromises. So these are still a common nuisance, and they can lead to things such as wire fraud, phishing, multi-factor authentication bypass, and so on. We're seeing software vulnerabilities on the provider end, so things that are entirely managed by the service providers, by the software providers, that kind of leave backdoors open into client systems. And while there's some level of risk that can be mitigated, of course, contractually and by doing vendor due diligence, this, of course, does not cover all possibilities. We're seeing that the time to exploit new vulnerabilities, the ones that are disclosed on a regular basis, we're seeing threat actors jumping on them a lot faster, which kind of underscores the necessity of maintaining regular patches. The good news, however, is that with the frequency increasing and with kind of general awareness increasing, many organizations are better prepared for this kind of outsider threat. So they're more able to restore systems from clean backups, for example, and maintain service continuity in the event of a ransomware. But of course, there's always room for improvement on these things. There is also an uptick in insider threats, which can be a bit challenging to plan for, because they often come from people with authorized access that are being used illegitimately or otherwise violating the company's trust. And these can be kind of hard to predict how, when, and if they happen. And lastly, of course, we're seeing more law enforcement activity. So we're noticing that law enforcement is taking notice of incidents occurring earlier on, asking more questions, expecting more involvement. It's even happened a few times where, we're seeing organizations getting asked a number of questions by law enforcement before the incidents have even been reported to them. So they're definitely taking notice of these things. So moving on, we're also seeing an interesting trend towards ransomware without ransomware. So until recently, ransomware attacks have been following what we call double extortion, in which attackers are encrypting systems and then stealing data, demanding payment to unlock the systems using a decryption key, and preventing public exposure of stolen files on the dark web. But today we're seeing more of a shift towards exfiltration only attacks where no ransomware is being deployed at all, which begs the question, is it even ransomware at that point? The reason why hackers are moving away from encryption is because it's complex, noisy, and risky, requiring maintenance of persistent access, compromising privileged accounts, including administrator accounts, deploying security tools, and so on. So in light of these kinds of complexities and the challenges that are presented by actually deploying an encryption, and especially since organizations are increasingly able to deal with that aspect of an incident, it's perhaps not surprising, as surprising that threat actors are opting for a kind of path of less resistance. So in terms of new tactics, over the past few months, at least with some threat actors, we've seen a shift in how they're engaging during negotiations. So we pulled a few examples from websites that kind of track ransom notes. So these are from ransom notes that are publicly available. And as you can see, historically, there's been a kind of willingness to, hey, we're going to show you a couple files that we have to show you that we really have what we say we have. Or we'll give you a file list to show you, what we allege to have taken. But in recent engagements, we have even seen cases where the file list, where the threat actor would not even necessarily provide a file list, or would only provide like a certain percentage of the file list. So this marks a bit of a departure from norms where there was some level of transparency, some back and forth, even in the context of an illicit, an illegal kind of context. We're still seeing a level of transparency that's maybe on the downturn. We're also seeing an increase in attacks that are being conducted by ransomware groups that were previously not known. So new ransomware groups that don't necessarily have a reputation. This also poses a challenge during negotiations because organizations are often relying on a threat actor's track record when deciding whether or not to make a payment or even to engage in communications, particularly surrounding the reliability and deleting stolen data or providing decryption keys. So when we don't have a reputation, organizations are generally less likely to do those kinds of things because there's no assurance of actually honoring the promises that are being made in the negotiation. And there's, of course, the emergent risk of a re-extortion attempt in those circumstances. So speaking of re-extortion, I'm going to throw it over to Daanish to talk a bit about PowerSchool.
Thanks, Alex. So yeah, as you can see on the screen, this is a screenshot from a website belonging to PowerSchool. Some of you who are watching may have heard about this incident. It was fairly widely publicized. PowerSchool is a software provider to many schools in North America, or school divisions in North America and elsewhere. Basically, the schools used the software to store various information, including student and teacher information. And the hackers in this case hacked PowerSchool, and as a result of doing so, copied data that belonged to those various customers or that related to their schools. And as Alex mentioned, we do see double extortion quite often, which is where a hacker extorts you both for the virus that they spread on your system and for the data that they've stolen. And as he also mentioned, now we also see more oftenly just the second one, where they just extort you for the data. It is, however, in our experience, rare to see re-extortion, where they try to extort you once for something and then pay you, and then you pay, and then they try to re-extort you. However, in this case, even though PowerSchool publicly admitted that they did make a ransom payment to these threat actors, about 5 months after that, a threat actor, or whether it's the same person that caused the same incident or a different hacker, it's not clear, someone reached out to some of the schools whose information had been affected in an attempt to extort them as well for money. It wasn't the schools that originally made the payment, but essentially these hackers tried to re-extort or get two payments in respect of the same incident. We don't see that type of re-extortion very often in our practice here at Fasken, but certainly an interesting occurrence in this case. Back to you, Alex.
Thanks, Daanish. So last but not least, sorry, just going to go back a slide. We, of course, have to talk about the use of artificial intelligence in the ransomware context. So the good news is you're probably already using AI in your business, maybe even for the purposes of maybe even within cybersecurity and security processes. But the bad news is so are the threat actors. So are the bad guys. This is because, well, one of the things that we're noticing is that artificial intelligence is lowering the barriers to entry into the ransomware sphere, is resulting in a higher volume and impact of attacks, and also makes lone wolf individual threat actors, makes it easier for them to operate. So AI can be used by threat actors for a number of reasons, or a number of purposes, I should say, including reconnaissance, social engineering, phishing, evasion of detection. Can also be used to identify high-value personal information or corporate information that they will target to exfiltrate, encrypt, or delete. And it can also even be used to develop malware. So we're also, curiously enough, seeing it potentially being used to draft messages within ransomware negotiations, as we're noticing the quality of the English is getting a bit better. So it's not because the threat actors have outsourced into Canada, and that's all the more not the case if you're seeing a lot of bullet lists where there don't need to be bullet lists, and M dashes, of course, in the messages. So with all that said, I'm going to throw it back over to Nareg, who's going to talk a bit about the regulatory developments.
Thanks, Alex and Daanish. Super interesting, and as you can tell, a very dynamic landscape in cybersecurity. And the regulators have been reacting and legislating in that sense. So quickly, we'll run you through the different pieces of legislation that have been adopted or have come into force or are being contemplated right now. A slide full of acronyms and letters will demystify all of that and tell you what it means. So at the federal level, we have Bill C-8 that was tabled recently. You might have heard of Bill C-26, essentially an act to reinforce Canada's critical infrastructure landscape, so targeting the energy sector, telecommunication, banking, and transportation, requiring mandatory minimum cybersecurity requirements and cybersecurity breach reporting. Also at the federal level, you might remember Bill C-11 died on the order paper. Bill C-27, its successor, also died on the order paper, but soon to be revived according to some sources. And that revival will happen likely without the Artificial Intelligence and Data Act, which was somewhat controversial when C-27 was tabled. Quebec has finally finished its adoption in 2024 of Bill 64, Law 25. So the last wave came into force in September 2024. So in 2025, the Autorité des marchés financiers, so the Quebec Securities Regulator, adopted additional regulations for companies in the financial sector, aligning with those of the Office of the Superintendent for Financial Institution, but somewhat stricter as well, with additional reporting requirements for the 30 days following the breach, and every 3 days after it was reported until the matter is closed. In Ontario, Bill 194 came into force, amending amending FIPA. So it requires mandatory notification from public bodies. Entities subject to municipal FIPA are somewhat exempt, but the Information Privacy Commissioner expects municipalities to also report breaches to the IPC as well, and to individuals. In Alberta, the Public Sector Freedom of Information and Privacy Act was replaced by, was split into two. So the the Access to Information Act and the Protection of Privacy Act, and adds mandatory breach reporting for public sector organizations in Alberta, similar to that which existed under Alberta's private sector PIPA. In Nova Scotia, Freedom of Information and Protection of Privacy Act, amended in 2025, which is going to also require reporting for public sector organizations, but only comes into force in 2027. Finally, and worth noting, just developments globally. So in January 2025, the Digital Operational Resiliency Act came into force in Europe. And it will have an impact on Canadian organizations with operations in Europe, specifically financial organizations. The breach reporting regime is similar to the one Quebec adopted, a bit similar to the one under OSFI, and also requires mandatory measures ahead of time, such as having an incident response plan. So that's in terms of what the legislators are doing. Let's take a look at what the regulators are doing. The Quebec Privacy Commissioner, and some of you might be familiar with the slide, I'll run you through it. Last year, we had a bunch of very nice numbers for 2022, 2023, and 2024 about how many breaches were reported. The commissioner was publishing all of that information. They stopped, hot take, in May 2025. They finally changed their opinion on this, and they stopped publishing all of that. In addition, we're not aware of any fines or penalties related to breaches from the Quebec Privacy Commissioner, although they have the power to impose administrative monetary penalties up to $10 million, fines up to $25 million. We have not seen those so far. What we have seen, and we continue to see, are requests to our clients about asking what type of measures were in place, or asking why did it take so long perhaps to report the breach, or requesting the results of the investigation or recommendations made by external cybersecurity experts. This is the update from the Privacy Commissioner. A quick translation for those attending in English is we are stopping the diffusion of privacy breaches to minimize the risk of harm to citizens and to balance to avoid disclosing of a technical vulnerability or cybersecurity issues to the broader public, to avoid harming the management of an incident, and to allow the commissioner to investigate without external interference or without impacting any investigations. At the federal level, we decided to focus on one update. There's a decision that came out in June of 2025. Some of you may have heard of 23andMe. 23andMe runs a genetic testing platform where you get to find out about, you submit a vial of your DNA, and they tell you about your genetic makeup. So in April 29, 2023, and for a period of about 5 months, there was a bad actor that managed to access 18,000 accounts. But the breach affects about 7 million customers, of which 320,000 people in Canada. The federal commissioner joined forces with the UK Privacy Commissioner to investigate this. The data, as you can tell, is relatively sensitive. Namely, it also contains raw DNA data. What happened, and what's particular in this breach, is that 23andMe was not breached directly. So its users, 18,000 of them, had reused passwords that were breached in other breaches, and the bad actors used those passwords to be able to gain access to the accounts. The commissioner, two things to note here. The commissioner highlighted that 23andMe still had a responsibility to safeguard personal information, said there's no mandatory MFA that was in place, inadequate minimum password requirements. They should have checked for previously compromised passwords. There was no additional safeguards, to access the raw DNA data. So it's interesting where it's an interesting case where the users contributed to the breach, but the commissioner still found that under privacy law, the organization was responsible for upholding minimum security safeguards and preventing credential stuffing attacks. And last but not least, in Ontario, there was a decision that we had mentioned last year as well, a series of 4 decisions where there was ransomware cases, and the Information Privacy Commissioner concluded that where information was encrypted but not actually accessed, there was use and loss in such that privacy laws were triggered. The divisional court came to confirm this, irrespective of the arguments that were made by the applicants on judicial review, essentially saying that encryption is akin to a transformation and falls under the definition of use. So it was both handled and dealt with, essentially. They didn't speak about loss, saying that they already concluded that the standard of reasonableness was met by the IPC. This essentially says that the IPC's view became law to a certain extent. With that, and on the litigation landscape, I'll pass it over to my colleague Daanish, who will run you through our litigation update.
Thanks, Nareg. Now that we have taken you through some cybersecurity incident trends and regulatory updates, the last cyber-related issue we wanted to provide a brief update on is litigation updates. In terms of cybersecurity litigation, most cases in Canada to date have related to hacking incidents. Since 2012, there was a flurry of class action lawsuits, in particular related to the tort of intrusion upon seclusion, which is a common law tort that the Ontario Court of Appeal first recognized in 2012. As some of you in the audience may know, though, the Ontario Court of Appeal clarified the application of that common law tort back in 2020 in a trilogy of cases, all of which were denied leave to the Supreme Court of Canada. In short, the Ontario Court of Appeal found that the tort of intrusion upon seclusion, which they had recognized in 2012, was not applicable to a, quote, database defendant, which is essentially an organization that had experienced a cybersecurity incident that led to a privacy breach. This was, of course, welcome news to many organizations because prior to the trilogy of cases, plaintiffs' lawyers were often bringing privacy breach class actions focused on this common law tort. So far, the Ontario trilogy has been followed, including in some other provinces. However, in light of these decisions, some plaintiff counsel have tried to find new grounds for claims related to cybersecurity incidents. The more recent focus for plaintiff counsel has been on a statutory tort related to privacy breaches. There are 4 provinces in Canada that have provincial privacy legislation with a statutory tort like that, including perhaps most notably British Columbia. You'll see various citations to British Columbia cases on the slide. In 2024 and in 2025, there have been a number of decisions in British Columbia where courts have found that this statutory privacy breach tort can potentially ground liability in a database defendant case. These decisions have often been at the early stages of class action litigation and not at the merits, but nevertheless, they are noteworthy. In one such earlier case from the British Columbia Court of Appeal, the defendants argued that the court should follow the Ontario trilogy of cases, since, like in those cases, the matter involved a third-party hacking. However, the British Columbia Court of Appeal found that the privacy breach tort that existed in the statute differed from the common law tort that was recognized in Ontario and could be potential grounds for a claim. In a particularly noteworthy part of the decision, the court said, and I quote, "I recognize the legitimate fears of the defendants that they could be routinely subject to large claims for damages for violations pursuant to this Privacy Act. But I see the floodgates argument differently, and that is as a flood of unprotected personal information flowing out of the control of persons whose information it is, and into the hands of bad actors, unless the law responds adequately." I think this quote from the decision provides you a window into why the court was hesitant to strike out this cause of action under the statutory tort at an early certification stage. There is one case in British Columbia, though, where that was heard on the merits and where the Court of Appeal upheld the damages of $15,000 per person related to a statutory privacy breach. The court in that case noted that the $15,000 is the baseline award for privacy breach, and that members of the class could seek to provide additional or prove additional damages that they suffered from the breach. However, that was not a hacking case. It was a case involving a former employee intentionally and nefariously accessing the personal information of customers in order to sell it to criminals. So a bit of a different circumstance there, but still noteworthy for using this statutory tort. Another notable case that the Plaintiffs' Counsel has started to bring after hacking incidents is against service providers. For example, litigation has been brought against PowerSchool, the case we talked about earlier when Alex Shapiro, my colleague, was speaking about the service providers to schools in relation to the incident we talked about. Lastly, I just want to note that there has been a trend recently of claims relying upon the intrusion upon seclusion tort from Ontario that was created in Ontario and the statutory privacy breach torts outside of the context of cybersecurity. So, for example, some claims have been brought against organizations alleging misuse of data, and the basis for those claims being the two torts. This may become a more frequent type of claim brought particularly in light of the Ontario trilogy of cases. So just as a quick summary, in the past few years, there have been various developments in cybersecurity litigation cases, with previously popular causes of action likely not being as viable as they once were. But plaintiff counsel continue to find new causes of action and bring new claims. And that's it for our section on cybersecurity trends and updates. I will now pass it to our colleagues Soleïca, Summer, and Dongwoo, who will be talking about compliance with privacy laws in Canada. Over to you.
Good afternoon. My name is Dongwoo Kim, and I'm an associate in Fasken's Privacy and Cybersecurity Group. I'll be facilitating today's session in which we'll survey key issues in privacy compliance across Canada in a Q&A format. I'm here with my colleagues, Soleïca Monnier and Summer Lewis. Soleïca is based in Fasken's Montreal office, and Summer is in the Toronto office. While both of them are experts in all things privacy, Soleïca will largely speak from the Quebec perspective, while Summer will address the rest of the Canadian jurisdictions. Quebec generally has the most stringent requirements and serves as a benchmark for the rest of Canada, and that's why it was important for us to note that. So I'm grateful to have both Soleïca and Summer, who will provide us a pretty comprehensive overview of the privacy compliance across Canada. So we'll open with a pretty broad question. So Soleïca, what are some of the most common client mandates or questions you have seen on the compliance topic recently?
Thank you, Dong. So excellent question. I would say from a Quebec perspective, we still receive a lot of questions regarding the preparation, the implementation of privacy compliance programs. So this means that organizations are still starting their compliance process. There is an interesting thing to note. That is an interesting thing to note because the Law 25 that was enacted in Quebec in 2021, it's been years, right, since it was enacted, but organizations are still waiting at the last minute in order to start. I will also mention that we just launched a product, Law 25 trainings, on the Elixi platform. Elixi is a learning management software platform, and I will insert a link in the chat later in the presentation if you are interested in knowing more about this initiative from our Fasken privacy team. So going back to your question, Dongwoo, aside from the broader privacy compliance programs, we receive a lot of various questions with respect to privacy laws, with respect to Law 5 or health laws, and our colleagues are going to expand on that further in the presentation today. But most of them, or I would say part of them, are directed towards anti-spam rules and the overlap between the CASL, the Canadian anti-spam law, and Law 25. So basically, a lot of our clients think that if they comply with CASL, it also means that they comply with privacy laws, but that's not necessarily true because under CASL, you can deduce that you have an implied consent by the effect of the law. Whereas under privacy laws, you really have to collect a consent upon collecting personal information from the individual. So upon collecting, for instance, an email from your customers, you really have to add maybe a pre-tick box in order to make sure that you have consent, for example, to send newsletters. So that's a very common question that we receive. Another one I would say is related to privacy impact assessments. We receive a lot of files in order to assist our clients in completing that type of assessment, especially for the first few ones. Clients are not necessarily comfortable going forward with the full assessment by themselves, so they like to have our assistance in order to become fully autonomous. So that's also something that we're used to doing. And yeah, I think that would be two good examples.
Thanks, Soleïca. That's really interesting. And I'd love to chime in here to ask you, just based on questions I've seen from clients about how Quebec's privacy law might apply to them, what would you say to a client who tells you, my business maybe has only a few employees in Quebec. We don't have a really large presence there. how stringent do they, or how particular do they have to be about following Quebec's privacy laws? Is there any sort of leeway there, or on a spectrum of of risk? What is your opinion on how they should go about complying with Quebec's privacy laws?
Okay, that's an interesting one, Summer, because it's not necessarily because you have no establishment in Quebec that the Private Sector Act doesn't apply to you. There is also a full jurisprudential test in which you have to assess whether you have a real and substantial connection with Quebec in order to determine if the Quebec Act applies to you. I will not go into full details of the jurisprudential test, but I will also try to put a link to the decision if that's something of interest for the audience today.
Thank you, Soleïca. And Summer, I would like to ask the same question. What are some of the most common client mandates or questions?
Thanks so much, Dongwoo. So I think Soleïca did an amazing job. Even though she was speaking to the trends she's seeing in Quebec, I think a lot of those trends do overlap with the rest of Canada in terms of general, privacy program management concerns, consents, particular notices or disclosures that clients would like us to look at, in addition to privacy statements that might be posted on their website or an app, and internal privacy policies, of course. I think a recent trend, which I'm sure a lot of our panelists today are dealing with, are questions related to AI. And whether or not it's AI, just any new sort of technology that you're thinking of implementing in your business that might be collecting, using, or disclosing personal information, you always want to revisit those foundational documents. They're not stagnant. We always want to revisit them and figure out, are there new things that need to be disclosed, new processes that need to be included internally, for example. And when it comes to AI, that popular question about how personal information can be used to train AI is definitely one that we've talked to clients a lot about. So that is definitely a trend I've been seeing for the rest of Canada as well.
Thank you, Summer. And you'll also be talking about AI regulation in the next session. But moving on to question number 2. So we've been seeing more uses of biometrics. So information related to fingerprints, facial images, iris scans, voice patterns, etc. So I was wondering, what you could tell us as to what the organizations should keep in mind if they're using biometric information. And maybe, Summer, you could open this one.
Absolutely. I'm happy to. So this is an exciting one and quite recent. In August 2025, the Federal Privacy Commissioner released guidance on processing biometrics. There are 2 versions of it. So one is for private sector businesses and one is for federal institutions. And the guidance essentially is structured around the key privacy principles that are found in each of the private sector and public sector privacy acts. So if you're for those of you in the audience, if you're working closely with either of those acts, this guidance won't look completely unfamiliar. You'll see, using the private sector one as an example, you'll see familiar principles like identifying appropriate purposes, obtaining consent, limiting collection, use, disclosure, and retention. However, the new thing, the new parts of this that you want to pay attention to is how the guidance outlines for each of those principles what businesses must do according to what's in the statute, and then what they should do as a best practice when they're handling biometric information. So just in terms of setting the context, biometric information is defined in the guidance as information about biometric characteristics that have been extracted from biometric samples. So think about a photograph of an individual's face or a recording of their voice. The biometric information are the characteristics that come out of the analysis of those types of samples. And the guidance, of course, confirms that biometric information is personal information. And going a step farther, we also have a short list of considerations for when biometric information will generally be considered sensitive. So those 3 factors are when it can uniquely identify an individual, where it poses a high risk of harm to individuals where it's misused, or if it reveals other sensitive information about an individual. So, for example, medical or financial information. And these 3 factors are regardless of the context. Usually the analysis around whether something is sensitive is contextual, but because with biometric information, it's pretty stable over time, difficult to change, and it's really innately linked to an individual's identity. So when either of those factors are met, it will generally be considered sensitive personal information. And recall that with sensitive personal information of any kind, generally express consent is required. So that will be an important factor to keep in mind. And then my final nugget from this guidance for you is that as a threshold issue, it's not enough to find convenience in using biometric information. Thinking, wouldn't it be great? It would be so much easier if we can use this. There's actually an appropriate purposes analysis that the privacy regulators have set out for us. So before you think about asking for consent or going down, the longer list of privacy principles that would govern how you collect biometric information, you have to evaluate whether the purposes are appropriate. So you might think about whether there's a legitimate need, if the biometric information will be effective and reliable in meeting the intended purpose, and also importantly, if there's less intrusive means to achieve the same purpose, then likely biometric information should not be used in that case. So I'll pause there, and I know Soleïca has some comments for us as well from the Quebec angle.
Yeah, and I don't have a lot to add because thanks to the new OPC guidance, the principles are not very, very similar between Quebec and the rest of Canada. But I would say in Quebec, the necessity criteria is so important, and it is very often where the privacy commissioner, the Commission d'accès à l'information, finds that the use of a biometric system is unfortunately illicit. So only one out of the 13 reported cases in Quebec analyzing the necessity criteria have found that the system was necessary and therefore legal. So you see, your chances of implementing successfully a biometric system in the workplace in Quebec are very low. I think this can be explained by the fact that biometrics are very sensitive information by nature, and there are often less intrusive solutions that you can implement instead of a biometric system. So let's say you can use a PIN code to replace a biometric system, for instance. Generally speaking, an organization cannot implement a system just in case. You've mentioned it, Summer. It's the same in Quebec. It really has to be necessary. It cannot just be convenient. So that's something that is outlined very often in the Commission d'accès à l'information's decisions. I would say the main requirement between the federal regime, as discussed in the OPC guidance, and the one in Quebec comes from the law, the ALFIT, if I'm using the little name of the law. The main difference is that there is a requirement to notify the Commission d'accès à l'information before implementing the system. So there is a specific timeline depending on whether the system is based on a centralized database or a decentralized one. And lastly, we have published some articles on the topic of biometric systems and the definition of biometrics that I will also share for you to consult.
Thank you so much, Soleïca and Summer. We ran out of time. We actually went over time. Apologies for that. If you have any questions or would like to get resources that we mentioned during the presentation, they will be made available. And also feel free to reach out to us to get the links and the information that you need. So we had 2 more questions prepared, but we don't have time for that. So we'll hand over to Chris and Summer for AI regulation.
Thanks so much, Dongwoo. So you've already introduced me very well for our first session. So I'll just introduce one of our partners from the Toronto office, Chris Ferguson, who will be joining me for this update on AI regulation in Canada. So I'll start us off with a quick reminder of where we left off. So I think Nareg, or perhaps someone from our first cybersecurity update, mentioned that our previous AI legislation, which was combined with our privacy legislation, died in earlier this year when Parliament was prorogued. So we currently don't have any federal AI regulation, but Chris will speak a bit more to some predictions and some promises we've seen from our new AI minister shortly. But that's not to say that because we don't have federal AI regulations right now that we're in a legal vacuum entirely. There are still existing laws that otherwise would apply to the development and use of AI. So our existing federal and provincial privacy laws, for example, and employment laws would still be applicable. And two examples of this are Law 25 in Quebec, where there's certain disclosure obligations related to automated decision-making. And also in Ontario, starting in January 2026, job postings actually should disclose if AI is used in the hiring process. So that's a more recent development that is hopefully helpful for you in your planning with HR. And additionally, there are some investigations and guidance from privacy commissioners to help navigate through the use of AI. Surely will give us more guidance on how to treat personal information when developing and using AI, and fingers crossed, some more guidance on the training aspect I mentioned in our previous presentation. And then the final point here, which is an interesting one, and I believe we also received some questions about using AI in the healthcare context, or even just for taking meeting notes. So in Alberta, under their Health Information Privacy Act, there are specific requirements about conducting privacy impact assessments where new technology is used, which would also apply to AI. But now we have, as of last month, guidance from the Privacy Commissioner in Alberta about how exactly to conduct those privacy impact assessments, specifically for AI scribe tools. So for those of you tuning in from the health industry, that will definitely be a useful set of guidelines. And then the last interesting development comes from the public sector. I'll just briefly talk about this one. Earlier this year, I think, again, our first presentation on cybersecurity mentioned Bill 194. So the other piece of Bill 194 is the Enhancing Digital Security and Trust Act, and that came into effect earlier this year in January, and that applies to Ontario public sector entities. So this is really just a clue about where the common themes that might come up in some private sector legislation that we'll hopefully get later this year. So for example, developing and implementing an accountability framework is one of the requirements. There are certain disclosure requirements for the use of AI and ensuring human oversight. So a lot of common themes that we've seen across international AI legislation, and that we'll, hopefully see in private sector legislation as well. The bad thing about this is there are a lot of details missing, and we're still waiting on regulations to further set out these obligations in detail and specify which public sector entities are captured. So stay tuned for that, and we'll definitely provide updates as they come in. And I'll hand it over to Chris to look into the crystal ball and tell us what's next.
Thanks, Summer. Good afternoon, everyone. And so now we'll turn to some sort of federal developments and sort of see where the minister has sort of telegraphed with what we can expect in the future. So since the prorogation of Parliament earlier this year, which as Summer mentioned, ended the last privacy reform efforts, Prime Minister Carney appointed a new Minister of Artificial Intelligence and Digital Innovation, Evan Solomon. Late last month, the federal government also launched an AI strategy task force and a 30-day national sprint consultation on the future of AI. And that task force has been tasked to look at various aspects of AI, like research, adoption, commercialization, investment, etc. Regarding that AI consultation, organizations and stakeholders have only until October 31st to respond to the survey. So it is very much a sprint. And then the task force will share a report on those submissions and what they've received at the end of by November. And finally, the task force is set to deliver a national AI strategy by the end of 2025. Now, the AI minister also announced that the government is expected to table private sector privacy legislation in Parliament by the end of the year, with alluding to maybe AI-specific rules to follow later. In general, the minister over the summer repeatedly stated that it's important not to, as he said, over-index on regulation of AI. So the hope is that privacy reform and any subsequent AI-specific rules will be practical and allow organizations to continue to participate and innovate in new technologies. Some context on what privacy reform. So in the lead up of privacy reform, given the outstanding investigations into AI providers like OpenAI that Summer mentioned, there's some international and domestic context that's helpful. Last December, for example, the European Data Protection Board released an opinion on certain data protection aspects related to the processing of personal data in the context of AI models, and found that training AI models on data sets that include personal data can engage European data protection laws. And it found that an AI model is only considered as being free from personal information and or personal data, if there is an insignificant probability that there's direct extraction of personal data from the training data, and obtaining such data from queries to the model have an insignificant probability of releasing personal information. In addition, some European national regulators have commented on the legitimate basis as a ground of processing AI training data, specifically the French regulator, or web scraping, the Dutch regulator. And of course, we also had an Alberta court hold that the charter does not allow publicly available information that is published by an individual, willingly published by an individual, can be subject to privacy law. And of course, the quick context of the European rules is that PIPEDA is obviously consent-based. It doesn't include those alternative forms of consent. Next slide, please. So what can we do to lead up in new federal rules on AI? Well, organizations still, of course, have to comply with existing privacy laws, including for new and existing AI initiatives that may come in the meantime. So a couple of brief points of what can be done now. The first is to establish AI governance mechanisms, including by integrating them into existing privacy and compliance programs. Specifically, we should review existing practices and privacy programs that see if they can be adapted by AI by incorporating additional points of review that are more specific to AI. For example, sort of means to control privacy issues related to training data, if you're looking at a model, or the purposes for which personal information is used in connection with an AI system. And to that end, there are some references and resources such as the OPC's existing guidance on generative AI and the NIST AI risk management framework that can be helpful starting points. Then you can use those governance mechanisms to conduct risk assessments for new and existing AI initiatives. Again, it is important to review the existing assessment process to ensure that AI-specific considerations are incorporated and to establish any new AI-specific processes where there are gaps that can't be addressed by modifying existing assessment processes. And finally, it's important to document how your AI systems operate, the risk associated with the use of those systems with a privacy perspective, and then the mitigation measures that were put in place so you can comply with your existing openness and transparency requirements, but also help comply with new rules as they come about. And so with that, I'll hand it over to my colleagues, Daniel, Heather, and Julie to discuss health privacy laws in Canada.
Thank you, Chris. I'll just get us to the next slide. Great. So I'm Daniel Fabiano. I'm a partner in our privacy group, and I'm joined by my partner, Julie Uzan-Naulin, and also by Heather Whiteside, also in our group. This particular session, which will be a brief overview of health-related matters, comes out of some experiences that we've collectively had. And in advising clients in the health sector, we often encounter situations where multiple health privacy laws are implicated, sometimes in place of or in addition to Canada's 4 general privacy laws. So for example, an M&A transaction may involve the acquisition of a healthcare provider or a merger of 2 technology companies that provide services in the healthcare space, or a client that's looking to expand its business or expand, telemedicine business or virtual care business or the like, across Canada, whether coming in from the United States or starting in one Canadian jurisdiction and expanding. And so in doing this work, we often need to think through a patchwork of health privacy laws, how they apply. Do they apply in place of Canada's general privacy laws? Do they apply alongside those general privacy laws? And when I say general privacy laws, I mean PIPEDA federally, and then I mean the general purpose privacy statutes in BC, Alberta, and Quebec, which are the 3 provinces that have their own version of PIPEDA. Because healthcare occupies a special place, it has special rules, and most health privacy laws are roughly based on the 10 privacy principles that I think we're all familiar with under PIPEDA. But there are certain concepts that are unique to the healthcare space, or certain variations on those general privacy rules that we're otherwise familiar with. In some cases, privacy laws in the health space loosen the rules. So for example, they're a little more permissive and forgiving in certain contexts, but in other cases, they tighten the rules or they impose new or additional rules. So in the first part of our presentation today, we're going to talk about how this plays out nationwide, but excluding Quebec. And then after I speak and Heather speaks about the rest of Canada, Julie will then provide a more focused discussion on Quebec's health privacy regime, largely because it's the newest. Just to be clear, our goal is to give you a high-level overview of key areas of difference and similarity among the provinces and areas of difference between the general privacy laws. So if your organization operates in the healthcare space, we are raising compliance questions or issues, not to get into detail but rather flags that you may then take away and want to consider within your organization. And we do this because we've encountered client teams that are not aware of the fact that there are different requirements under health privacy laws, because perhaps the client teams are just focused on general privacy like PIPEDA, or because they assume that the health privacy law in their province imposes the same rules as other Canadian health privacy laws, which is often not exactly the case. So I'll dive in and we'll go to the first topic, which is to speak at a high level about purpose and application of the health privacy laws. As I mentioned, Canada has a patchwork of privacy legislation in terms of private sector laws, health sector laws, public sector laws, and then lurking sort of behind the scenes or across all of them, the common law. And so nearly all provinces and territories have enacted laws dealing specifically with health privacy. And that's, of course, the focus of today's session. The goal of health privacy legislation is to enhance privacy while also ensuring the efficient delivery of health services. This is a key difference. Because of the importance of the efficient delivery of health services, it is a counterbalance to what is otherwise, the normal concern about protecting privacy. Most provincial health privacy laws regulate the collection, use, and disclosure of personal health information. I'll refer to that as PHI. We'll just go to the next slide. By specific participants in the health sector. And they're often referred to as trustees or custodians. The specific terminology varies by statute. And who counts as a trustee or who counts as a custodian varies by province. Some health privacy laws take a broad approach to who counts as a custodian. So for example, in Ontario or in PEI, anyone who is providing or assisting in the provision of healthcare or treatment is a custodian. So for example, certain coaching and certain therapies can actually be considered healthcare, subject to health privacy laws. In other provinces, health privacy laws take a narrow approach. So for example, Alberta only applies to registered or licensed healthcare providers like physicians. Another complicating factor is that some health privacy laws are deemed substantially similar to PIPEDA, which means they apply in place of PIPEDA. This is the case in Ontario, New Brunswick, Newfoundland, and Nova Scotia. But other provinces have health privacy laws that are not substantially similar to PIPEDA. And so the PIPEDA and the applicable health privacy law may apply at the same time. Another important thing to keep in mind in the health privacy space is that there can be some overlap or some interplay between health privacy statutes and health regulatory obligations that might be imposed by, let's say, the College of Physicians and Surgeons in a given province that regulates doctors. So, certain rules around record keeping and how records are handled can also arise from those professional regulatory obligations. So, all this to say, it is a very busy national patchwork when it comes to health privacy. Given the slide deck's jumping around, I'm going to get someone else to advance the slide and to police where we're at on the slide deck, and I'll continue my remarks. We'll go to consent and we'll go to need to know. Consent requirements are another area of difference as between health and general privacy laws. And in fact, in some cases, it's a bit more forgiving. Health privacy statutes recognize the ability of custodians or trustees to assume implied consent to use PHI or to disclose PHI to other custodians, where it is necessary for providing healthcare or for assisting in providing healthcare, unless the individual has asserted otherwise. It's a bit of a mouthful, but the gist is, when it comes to healthcare by trustees and custodians, it's an opt-out approach to consent. An easy visual for this is a patient in an ambulance. Privacy consents are not top of mind in an urgent care situation, where unless you know the patient has expressed certain wishes, you, the paramedic in this example, would just go ahead and collect, use, and disclose that patient's PHI in the back of the ambulance as you need for care. You wouldn't stop and engage in privacy consent. Different health privacy statutes approach this topic somewhat differently, but in some cases it is certainly an assumed implied consent regime. When you're not in the care context, or where the information at issue is not needed for care, or you're sharing information with a non-custodian or a non-trustee, in those situations, express consent is required. Another aspect to flag is that health privacy statutes are also generally more nuanced than the general private sector privacy laws in terms of an individual's ability to withdraw consent or to condition their consent or to impose parameters. So that is to say, to fence in who gets to see their information, how their information is used, and the like. Sometimes this is called a consent directive. There are other labels that are used. But in the health privacy context, individuals, patients usually, have much more ability to, after the fact or whatever, to impose, to step in and to tell their custodian or their trustee, I don't want you to allow so-and-so on your staff to see my information. So another key area of difference. Let's jump to the next slide. And we'll talk a little bit about service providers before handing this over to Heather. So into the substantive side. Thank you. So as the case with general privacy laws, the custodian, the trustee is still accountable for the proper handling of PHI, even when they outsource it. But just in the interest of time, I'll sort of cut to the chase. One of the key differences in the health privacy context is it is often much more prescriptive than general privacy laws about what goes in a service provider agreement or an agreement with an information manager or an agent or an electronic service provider. There's a bunch of labels that are used. But the takeaway I wanted to flag here is if you are in the healthcare sector, whether as a service provider or a healthcare provider, you'll want to make sure that your contracts actually check the boxes in terms of what is specifically required. In particular, Alberta and Yukon tend to be a bit more prescriptive in terms of actually listing out a bunch of topics that need to be covered. And again, in a way that's much more focused than our general privacy laws. So Heather, I'll turn it over to you to talk about secondary uses.
Thanks, Daniel. So as Daniel outlined for us, the primary purpose of health privacy statutes is generally to govern the handling of personal health information in the context of the provision of healthcare to patients. But most statutes do set out circumstances where custodians or trustees can actually use patient health information without consent for secondary purposes. And by that, I mean purposes other than the provision of healthcare to patients. And this is one way in which health privacy laws are, in a sense, a little bit more permissive than the private sector privacy laws of general application. And it's really reflective of the healthcare context and the fact that personal health information often is necessary to serve broader public health purposes. So the statutes vary somewhat in terms of what specific purposes are permitted, but here on the slide, you'll see a few examples, which we've pulled from Ontario and Alberta's health privacy laws. So for example, without patient consent, we would expect a custodian to be able to use a patient's health information if it's necessary for training their fellow health service providers. I will note that some of the statutes also distinguish between which types of custodians are able to use personal health information for these purposes. So, for example, public health surveillance is often reserved for certain types of custodians, not just any individual physician, but more so, provincial health agencies or regional health authorities are able to rely on these permitted uses. In the next slide, we'll turn to the use of technology. And I will say most health privacy laws are not overly prescriptive about the use of technology by custodians. But on the next slide, you'll see that there are some key, sorry, let me back up a little bit. The same principles and rules generally apply to the handling of personal health information, regardless of what type of technology is being used to process that data. That said, though, there are some privacy and some health regulators and government agencies that have developed standards or guidelines for certain technology use cases. So, for example, here in Ontario, we have the Virtual Visits Verification Standard, which was developed by Ontario Health. And that is essentially a process where providers of virtual care solutions, so like secure messaging platforms or video conferencing platforms for the delivery of virtual care, they can complete a verification process that considers certain privacy and security criteria. And then once they're verified, custodians who are looking to employ or procure those types of technology solutions in their practice can look at this list of verified solutions to figure out which ones would be useful or supportive in helping the custodian meet their compliance obligations. In a similar vein, custodians who are looking at implementing new technologies might need to consider whether a privacy impact assessment is required, which is the case under a few health privacy statutes, or whether it's recommended as a good practice. Now, next slide, please. Two more, I think. We've highlighted a lot of similarities among the health privacy laws, but one notable difference that can often be overlooked are differences in breach reporting obligations. And that's because some of the health privacy statutes have a harms threshold. Many of you familiar with private sector privacy laws will be familiar with this, and it effectively means that a custodian only has to notify affected individuals of a privacy breach if that breach could reasonably be expected to create a real risk of significant harm. So the notice requirement doesn't apply just to any breach, it's only a breach that creates a real risk of significant harm, and that's assessed by thinking about things like the sensitivity of the information or the consequences of the breach. But some health privacy statutes raise the bar a notch by requiring notice of any breach that creates a risk of harm, whether or not it's real, whether or not it's significant. And then there are two jurisdictions, Ontario is one of them, where there's no harms threshold. And so that means that custodians have to notify affected individuals in any case where their personal information has been lost or stolen or used or disclosed without authority. So all to say, custodians who operate in multiple provinces should just keep in mind that there are these differences and should particularly be aware of the jurisdictions in which the reporting threshold is a little bit lower. So I'll now invite my colleague Julie to compare and contrast some of the topics we've talked about with the new regime in Quebec.
Thank you, Heather and Daniel. And yes, now we have a new regime in Quebec. A few years ago, we had Act 25, and now we have Act 5 on specific health matter. So what is Act 5 or Law 5 in Quebec? The Law 5 is specific to health and social services information. Most of the provision of the Act entered into effect last year in July, and the Act aims at ensuring the protection of health personal information and the handling of such information. And the other main objective of the Act is to establish a governance model based on transparency first and on accountability of stakeholders and organizations. As you will notice, the Act 5 is largely based on generic privacy law in Quebec, especially on the Access to Information Act in Quebec. So you will find some similarities between both acts. We are going to see in the next slide what is health information in Quebec versus what is personal information in Quebec. So there is a dual regime in Quebec for health body. So Act 5 applies to any body which is a public or a private body, healthcare institution, private health facilities, even sometimes universities and pre-hospital emergency services, which handle health information in the context of providing health services. So an organization, a health body can be subject to a dual regime, both the generic regime, privacy regime, and to the regime under Act 5. I mean that, for example, for handling human resources information, the body will remain subject to the general privacy protection regime. It can be the Private Sector Act or the Access Act, depending on the company. When the body entered health or social services information and provide, for example, a medical consultation, or something similar, the body would be subject to the Act 5. So the same body can be subject to two different laws in Quebec. It's the main difficulty, I would say, in this specific context. And now we'll see a broad overview of the new obligation and new specificities of Act 5 versus Act 25, for example. So regarding the obligation, we have new governance obligation for bodies subject to Act 5. We still have the need to obtain a valid consent for the use and the communication of health information, but the information to be given to obtain the valid consent is not really the same than the information to be given to obtain a valid consent under Act 25, for example. And in particular, Act 5 establishes new rights for individuals, including the right to restrict the access to someone's health information and also the right to deny access to their own health information. So it means that in practice, I can say, well, I don't want this person, for example, my husband, to have access to my medical record, for example, depending on the circumstances. So it is the right to restrict or deny access to my health personal information. In addition, Act 5 establishes an obligation to implement governance policies and practices to be compliant with Act 5. What does it mean? It means that your employees need to follow some trainings regarding the protection of health information. It means too that you need to establish specific conditions for retaining and destroying health information. You need to implement a governance policy which would be specific for health information, and also that you need to use in certain specific circumstances certified product or softwares. Let's dive into some other new obligation. So, one specificity of Act 5 is regarding contractual obligations. You know that under Act 25, when an organization contracts or enter into an agreement with a service provider, we tell you have to be sure that some provisions are included in the agreement. And it's the same thing here. But the provision must go beyond what is required under Act 25. I mean that you still need to have provision on the confidentiality, security of information you will communicate to the service provider. You may need the employee of the service provider to sign a confidentiality agreement, for example. But what is more stringent than under Act 25 is that when you said information must be protected, you mean that information must be protected to comply with information governance rules, for example, and specific rules defined, which would be defined later by the network information officer. In addition, another specific provision which is quite problematic for some of our clients is the one related to the fact that the health body can request you to provide the body at any time and free of charge any information the service provider has obtained or has produced in carrying out the agreement. So it's a real new stringent obligation which is imposed on service provider. Lastly, the agreement must specify that the service provider must only use technological products or services authorized by the health body. So, as we see, we have the basic provision provided by Act 25, but in a Law 5 agreement, we must add additional provision which make the obligation more stringent on the service provider. And even if the service provider is a IT company, so which is not directly subject to Act 5, this company can be indirectly subject to Act 5 through the agreement. New obligation or new rules regarding to access to information by researcher. It's really new, and the Act 5 regulates the use of health information without consent of the individual by researchers. And Act 5 makes a distinction between a researcher attached to a body and other researchers. The process is quite similar, but not fully similar. I mean that any researcher must make a written request to obtain the access to information, to health information. This written request for researcher attached to a health body, this written request must be made to the highest authority within the body. For other researcher, researcher not attached to body, this request must be made to it must be made to Access Research Center, which is now Santé Québec. Once the request has been made, the body or the Research Access Center analyze the request, ask a question, and then give or not, but grant the approval to access to health information. And then a written agreement between the researcher and the body shall be entered into. So the process shall follow a specific process, actually, depending on whether the researcher is attached to a body or not. And to be considered as an attached researcher, the researcher must demonstrate that he has a connection with the body. It can be an employee or a physician working in a specific hospital, for example. Another new obligation is related to certification of product. As I said earlier, for example, service provider must use specific IT tools. And in addition, health bodies must use certified technological product. So a technological product or service is a kind of application. For example, an application for an hospital to schedule appointments between patient and physician. It can be a software to fill a patient file. So there only certified technology product in principle may be acquired or used by a health organization. We'll see. Lastly, confidentiality incident. Basically, it's similar to what happens under Act 25. the notion of confidentiality incident is still relying on the assessment of the risk of serious injury. So to assess whether there is a risk of serious injury, we will need to determine the sensitivity of the information concerned, which in case of health information is quite obvious. The information is necessarily sensitive. The anticipated consequence of it is used, and the probability that information would be used for harmful purposes. And then if the threshold is met, we'll need to notify. And here is the distinction with Act 25. There is an obligation to notify the Québec Commission d'Accès à l'Information and the Minister of Health and Social Services, not only the Québec Commission d'Accès à l'Information. There is also an obligation to notify the individual impacted by the incident, and on an optional way to notify any person or body that can reduce the risk. So, as you have seen, the process is similar, but with specific difference because of the specific and sensitive nature at stake of health personal information. So now we are going to have time for some question and for the Q&A. So it's time for Kateri and Alex to handle the Q&A session. Thank you.
Great. Thank you, Julie, and to the whole team. A lot of very important developments obviously occurring across the country. We do have some questions that we'll address here in the Q&A section. If anybody does have additional questions, please feel free to submit, and we'll try to make some time to get to them here before we wrap up. The first one goes back to our cybersecurity panel group, and the question being, with the changing tactics that were described with the attackers' approaches to how they're perpetrating these attacks, are we still seeing ransom payments being made? And if so, what are some of the factors that drive those decisions typically?
I'll jump on this one, Alex. That's a great question. So to address the core of your question, yes, people are still paying ransoms. However, it's always a discussion that's done with counsel and sometimes or often experts who engage in these negotiations. I'd say there's three items that come to surface when we're discussing. First is operational concerns. If there's no viable backups and no way to recover, oftentimes it's driving the decision to pay ransom. Whereas if we're able to get back on our feet with backups, like Alex mentioned, and more organizations have those backups, well, then a ransom becomes less interesting. The other item is the trustworthiness and the reputation of the threat actor. So with these new groups, it becomes tougher to be the first one to make a payment. Whereas when somebody has an established reputation and decryptors that work and they've made good on their promises, well, it's easier to wrap your mind around throwing money across the fence and hoping that the bad guys deliver. There's some honor among thieves, but it works on a reputation system. And then finally, it comes down to price. Whether you like it or not, when we have conversations with the clients, for $20, everybody's ready to pay $20 and get rid of everything, right? So is it coming in at the right price where it makes sense for businesses to move forward? Importantly, what's not part of the considerations is, does it alter privacy obligations? And commissioners have repeatedly said paying a ransom does not change your real risk of significant harm or risk of injury analysis. So your privacy law obligations don't vanish just because you paid a ransom. So we advise oftentimes clients to not factor that into their decision making.
Thank you very much, Nareg. I do have a question for another group. Soleïca, this one's for you, given the new privacy impact assessment requirements introduced by Law 25. We have received some questions from the audience prior to the webinar asking about these privacy impact assessments, EFVP as we call them, and whether there were any solutions to gain efficiency and to ensure compliance with the law when you are preparing them.
So on the methodology, privacy impact assessments can look a bit burdensome, but in reality, I think the first one is the worst one, if I can put it that way, because as soon as you start, you really familiarize yourself with the process and you're really able to do it in a more seamless way throughout. Of course, we always, as I mentioned during the presentation, we always advise having some assistance, at least for the first few ones, because that way you really get to develop your reflexes, and it becomes way easier to get through the process. It's typically divided in two parts, the PI itself. The first one is you have to go and contact your teams in order to collect some information on the specific project or the specific communication, depending on the use case. And the second part is really the assessment, in which the privacy officer or its designated team will assess the answers that they were given in order to determine what the risks for the affected individuals are. And based on these two assessments, you will reach a conclusion in which you will either approve, refuse, or approve with recommendations the project.
Thank you for this answer.
Great. We had another question as well to the same panel on the privacy compliance topic. This is regarding the question of whether a particular collection, use, or disclosure of personal information is necessary to achieve a purpose, which is obviously a relevant question both under PIPEDA and also in Quebec, as was discussed. It sounded like the test was stricter in Quebec, possibly much more strict than under PIPEDA. And so question for Summer and Soleïca, if you could comment on how that requirement of necessity is applied under those regimes, that would be helpful.
Sure. So Summer, if you want, I can start with Quebec and you can add anything you want to my answer. So the necessity criteria, I don't know if I would say that it's stricter in Quebec, but I think that with respect to certain topics such as biometric systems and video surveillance, it definitely is interpreted in a stricter way. That's for sure. But for some other topics, it's not necessarily interpreted or assessed as part of the Commission d'accès à l'information's decisions. In terms of the test that you have to fulfill, there are two parts again. The first one is you have to determine if the objective pursued is legitimate, important, and real. And then you have to determine if the intrusion into privacy is proportionate to that objective. And lastly, you will be able to determine if the collection, use, or disclosure of the information may be carried out. It may be carried out if it is clearly more beneficial to the organization or business than it is harmful to the individual concerned. And Summer, maybe you can add anything for PIPEDA?
Absolutely. You might recognize just a few of the criteria that Soleïca just listed. A lot of them are similar under PIPEDA. So just in terms of her comment about it being a contextual analysis, and it really depends on, the type of information we're talking about. Earlier, we gave an overview on, biometric information, for example, being seen as more sensitive personal information. So that degree of sensitivity will be part of the analysis. A similar wording to what Soleïca mentioned in terms of whether the organization's purpose represents a legitimate need or a bona fide business interest. So there's some similarity there. And then also whether the collection, use, or disclosure would be effective in meeting the organization's need. There is also a proportionality sort of analysis, whether the loss of privacy is proportional to the benefits that the organization would gain. So that is also similar to one of the criteria that Soleïca listed. And then something I had flagged earlier in the biometric information overview was whether there's a less invasive means of achieving the same ends. And just, looking at case law and how that's been interpreted by the court, you may think about it from like a comparable cost perspective or comparable benefits perspective. And I think an important thing to note, and it's always a fun conversation to have with clients, is whether it is sufficient to comply with other parts of the act, and it sort of will help you get away with not having a reasonable or necessary purpose. And by that, I mean, for example, if you obtain consent for what would otherwise be an unreasonable purpose, can you just, go ahead with that collection, use, and disclosure? And the answer is no, because you do have to fulfill this obligation of ensuring that it is a reasonable purpose and sort of go through this analysis before you even think about obtaining consent. So hopefully that gives a helpful overview for the federal privacy legislation.
Thank you, Summer. We are almost at time, and I want to take a few seconds to indicate that the link for the Ontario Quebec Law Society certificates is now on the screen. We've added also for our BC viewers, the Law Society of British Columbia title. So also don't forget to fill out our survey. It does only take a minute and it is so helpful. So on behalf of myself, Alex, and all the members of the team whom I thank for their excellent presentations, we want to thank you for joining us today. Hope to see you next time. Have a great afternoon, everybody.